Ladies and gentlemen, good day and welcome to the Nishith Desai Associates conference call on NDA series on Insolvency and Bankruptcy Code, recent jurisprudence issues and proposed amendments. As a reminder, all participant lines will be in the listen-only mode. There will be an opportunity for you to ask questions after the presentation concludes. Should you need assistance during the conference call, please signal an operator by pressing star then 0 on your touchtone phone. Please note that this conference is being recorded. I'm now glad to hand the conference over to Mr. Desai. Thank you and over to you, sir.
Thanks a lot. Thanks a lot for everyone joining this conference call. Along with me, I also have my colleagues, Simon Rees, who heads the M&A and private equity practice at Nishith Desai Associates. Along with Simon, we also have Karan Kalra, who is also part of our M&A and private equity practice and heads banking finance vertical at our firm. And also, we welcome my colleague Arjun Gupta, who is a senior member of the dispute resolution practice and leads the initiatives on the insolvency code and the matters related to that practice. So, with that brief introduction, uh, we may straight away, start and go on to the subject. So, the idea behind holding this conference call, particularly on this subject, is very obvious. We have the Insolvency and Bankruptcy Code 2016, which practically got implemented in December of 2016. So we are about 15 or 16 months since this code has been in action. And as everyone would agree on this call, uh, there has been quite a few significant developments, both in terms of jurisprudence and practical issues which have emerged as part of this code, which in a way first time in the history where we have a major overhaul already planned in 2018 for a code which was introduced in 2016. So this gives a clear indication as to how important the provisions of this law are and how quickly things are changing when it comes to the issues of insolvency, bankruptcy, and restructuring as far as India is concerned. We could not have timed it well so far as this conference call is concerned because as we talk today, Supreme Court has already issued a notice in a petition where there is a substantial challenge to several provisions of the code itself, including the very provisions of initiation of the insolvency proceedings by financial and operational creditors uh, on the questions of constitutional rights, the very appointment of tribunal members in the NCLT and NCLAT, and many more other provisions which have been challenged on the basis of violation of certain constitutional rights so far as the code is concerned. So I think this topic definitely brings a lot of attention, and that was the reason why we thought it may be a good idea to do a series. So for the purpose of the participants, this is not the only conference call that we are arranging. We are planning to have a series of such conferences on this code, uh, typically on every fortnight on a Tuesday. And we will make sure every one of you are intimated in advance if there is any change with this regard, because there are several topics that we want to discuss. Not only that, we would also, as part of this initiative, create some kind of a white paper which possibly can be addressed to the committee which is looking at the overhaul, not only in terms of the suggestions to the amendments, but also some of the aspects which still needs to be considered, which may not have been addressed, which everyone present on this call are invited to provide their suggestions as well. So with that background, let me just give a little overview on the code, and the reasons why this code was formulated in the first place. So as we know, recovery and restructuring of debt is not a new subject. We have proceedings which allow such recovery and restructuring very much there for decades now. But what was happening before the code came in, we had several different provisions and several different laws which affected this subject. So we had on one hand our civil procedures, which allowed recovery irrespective of which category of lender or creditor you are. And then, of course, we had Companies Act, which allowed winding up through the liquidation proceedings, subject to, of course, the other provisions of the Companies Act in relation to restructuring. Then came the Sikh Industrial Companies Act, formulating the Board of Industrial Finance and Reconstruction somewhere in mid 80s, where the thrust was to restructure and see what can be salvaged out of the companies which are going negative in terms of their net worth. uh, and somewhere we all accept that provisions and that procedures were not either implemented well or were not in terms of what India needed to address those concerns. Then there was a separate category of lenders, which was banks and financial institutions, where the parliament brought the DRT Act to bring in a special provision for a summary trial to recover the dues due to banks and financial institutions. That in itself were possibly not sufficient, and then we got our SURFACE Act in 2002, which basically said that you first take an action and then go to court, rather than first go to court and then take an action. Somewhere those provisions have also possibly not addressed the concerns which the economy needs to be addressed on an urgent basis, and that's what I feel that the formulation of the insolvency and bankruptcy code came in, where all of this has been consolidated into one act, and given the powers to NCLT, which was also formulated as part of the amendments which were brought in as part of the insolvency and bankruptcy code in 2016. So here we have a code which consolidates most of these laws and provisions to enable a very quick resolution of a situation where there needs a restructuring exercise to be carried out, or if that doesn't happen, then of course take the company to liquidation, and also bring in some efficiency there. So without going into too many aspects of the code, uh, in our view there were five major changes or five major provisions which the insolvency code brought in to bring in the effectiveness and efficiency in the process of restructuring and recovery. I think the first and foremost, everyone agreed that delay is the biggest factor which is affecting the way the restructuring and recovery process were happening in India, and therefore the time limits were introduced. As you know, we have now a strict timeline of 180 days to restructure, extendable to 270 days. And if a resolution is not formulated within that time period, then the company goes into liquidation, again under the same code and under the same process, or under the same adjudicating officers. Now, obviously, this provision also today in the Supreme Court petition has been challenged, but so long as it stays, that's how the time limits has been fixed. Then there was a concept of committee of creditors, which was a little different than how we used to see earlier. So in BIFR, we used to see secured creditors, and then the biggest lending institution taking a lead, and the others coming through. In the schemes related to which RBI floated for restructuring, we saw a very different joint lenders forum being formed. In terms of uh, other provisions, we surfacey, we saw 75% of the again secure creditors coming and taking decisions. What code provides is a committee of creditors comprising of all the financial creditors, but it excludes any other category of creditors, including operational creditors, to have any say in terms of taking the decision. So I think the power and the focus shifts on the financial creditors so far as the company which is going through this process. The third concept which has been introduced, and which is completely different than any other provisions earlier, because earlier if a company was going into liquidation, we had a government institution like the official liquidator's office, and in BIFR and others there were no outside agencies brought in for the purpose of resolution. Here the concept of resolution professional has been introduced, where uh, private individuals and other institutions who are capable to handle such complex issues of resolutions have been given powers to be appointed and take the resolution to its logical end. So, in our view, that is one of the biggest change which the insolvency code brings in. Uh, the fourth point which we would want to highlight is uh, the kind of discretions which the adjudicating authorities, courts in winding up and otherwise were exercising were pretty wide. I think the way the code has been written, a lot of procedures and strict rules have been introduced to minimize the discretion, to ensure that the intent and the objective of the code is followed to the extent possible. So I think that is another uh, change the way the code is written. And the fifth one, which again, in a view, is a game changer, because the liquidation preference, as provided under Section 531A of the Companies Act, has been significantly changed the way the liquidation preference is provided as part of the insolvency code. So I think there has been pretty much quite a few a number of issues addressed, which we all have faced in last 3 decades as part of different provisions and law which apply to this issue of recovery or restructuring of companies in India. Of course, nothing goes without uh, conflicting jurisprudence and challenging when it comes to India. So I think this code also went through a similar path, and we saw within an year several different judgments and conflicting judgments came in from NCLT, NCLAT, and to our surprise, many of those even reached Supreme Court and got finally ruled on, where Supreme Court has also clarified on several different aspects and laid down law. In some ways, some of those judgments have found its way in the proposed amendments, which Simon and Arjun will touch upon little more in detail. But to just highlight maybe 4 or 5 judgments or 4 or 5 topics which deal with the jurisprudence, which have been the most important reasons why we are also seeing the proposed amendments. I think the first one which I would touch upon, which will be elaborated more in detail by Arjun, is the issue of invocation or proceedings against the guarantors of the corporate debtor who is going through the insolvency process. I think there were a couple of NCLT judgments which were taking a particular view in terms of whether you can take an action against the corporate guarantor pending the insolvency proceedings against corporate debtor, while I think Allahabad High Court and NCLAT taking a little slightly different view, considering that this aspect is not covered uh, in an elaborate manner in the provisions of the insolvency code. Not only that, but I think we'll also touch upon the issue little in detail again as to whether you can also invoke a guarantee against the corporate debtor itself, which is going through the insolvency provisions, because unlike the provisions of the Sikh Industrial Companies Act, which had wider provisions which vis-a-vis the suspension of proceedings and contracts as provided under Section 22, the moratorium as provided under the Insolvency Code is, in our view, not as wide as it was written in the earlier provisions under SICA. So we'll also touch upon some of the nuances which it gives for the matters of interpretation in relation to such invocations, and it can become uh, pretty important as we go along under this code. The second aspect was a bit innocuous, but it went all the way up to Supreme Court, where Supreme Court had to say in Lokhandwala matter that yes, and the code is not giving any power or authority for the NCLT to allow a settlement or a withdrawal post admission of the matters, and Supreme Court had to invoke its inherent powers under the Constitution, but also made a noting that the ministry should look into this aspect and amend the law so that not every such matter comes to Supreme Court. So we are seeing those provisions already proposed in the recent amendments as being discussed by the committee. Then there were a few technical aspects like what kind of certifications required to be submitted, particularly in case of foreign creditors, because it talked about banks as defined under the Indian provisions, and it was a procedural hurdle for many creditors to initiate insolvency proceedings in India. So I think that again Supreme Court clarified that some of these administrative hurdles should not come in way to the object of the act. Similarly, the powers to issue demand notices, whether it can be delegated to lawyers. We saw the judgment under Macquarie, which again clarifies both these aspects, and we'll also touch upon some of these aspects as we go along in this series. Uh, 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 Today or maybe next time when we are holding this in a fortnight from now. So with that, I think with that background and with that understanding, the way we are proceeding today, Karan will touch upon some of the recent practical matters which are pending before different NCLTs, particularly which are the big accounts which RBI has referred or in a way insisted that banks should go through insolvency rather than DRT or any other route. So Karan will touch upon some of those practical examples and the lessons learned, and then we'll go to Simon and Arjun to cover the amendments, which today we are only going to cover two. One in relation to the eligibility of the bidders and the amendments related to it, and second in relation to the provisions in relation to the invocation of the guarantees in relation to a corporate debtor. So, with that, over to Karan, and we'll be happy to address questions at the end of the sessions after Karan, Simon, and Arjun have given this overview. Thank you.
Thanks, Rapat. I think that was a fantastic overview of where the lay of the land is and where we are now and where we want to go from here. So really, when did this entire saga start, right? As Vyapak rightly mentioned, there was the enactment, of course, of the IBC, but where did we go from there? I think the first thing was that the RBI went out there and said, look, there are these 12 large cases, which in RBI's view actually constituted 25% of the outstanding bank NPAs or Indian bank NPAs at that time. And RBI said we want that these cases be necessarily referred to the process and be taken up. Now that was interesting because it was actually the first time where RBI was pinpointing specific assets that should be dealt in a particular manner, going beyond arguably what the power of the RBI was. It was a supervisory power always, right? But rightfully so. I think the message that was sent was very clear. There are these cases, and any cases of this nature must and must only be tried under this new process that we've brought about. And without putting the big cases in there, I don't think we were being able to address the NPA situation in any manner. I mean, it was the NPAs were growing, were consistently growing, and arguably, when you saw banks' prudential norms being tightened over the last 3 to 4 years, that number was ever increasing. Uh, so what really happened, right? When RBI referred these 12 cases, uh, what did everyone react to? I think everyone's first reaction was great. These are probably testing grounds. Let's see how these 12 cases really pan out and what happens in those. And also, it'll set an example for the second set of cases that RBI pinpointed, and banks and other institutions could directly bring to the code or rather to NCLT for resolution. I think it's important at this stage for us, just for a moment, and that's the point I'd like to cover. What have we learned from what has happened in relation to these cases so far? None of them are resolved yet. The process is still on. In fact, we're just about hitting the 270-day timeline on some of these cases. But what developments have happened thus far that have actually warranted, these series of reforms that the law committee, or rather the law committee on insolvency, has put out there, has suggested, deliberated, and of course we're all going to continue deliberating those. So what really happened? What I'll try and do is, without getting into the details of 12 specific cases, I've actually tried to bucket these, and at least for today's discussion, into 2, 3 topics that I'll take up front and mention a couple of others, and try and tell you what really were the issues there. And of course, my colleague Simon and Arjun will talk more about them. I think the first big issue that has come up is who can bid, right? Or who can really be an eligible bidder to bid and submit a plan and then take over the asset, or an effective plan to deal with the assets. Now, what we've seen in the past was that last year, through an amendment which was earlier an ordinance, Section 29A was enacted, which actually brought in a series of provisions that brought out who were ineligible, right? And while we'll talk about these more, I think it's good to know where this came from. I think the biggest reason or the biggest case for this was the SR Steel case. Now, SR Steel, as we all know, is one of the largest, or I think the second largest NPA in the country. And what happened was, when the resolution professional invited bids, there were 4 bids, or rather 4 serious bids received from Vedanta, Tata Steel, ArcelorMittal, and New Metal. Subsequently, what happened was that the bids submitted by ArcelorMittal and by New Metal were actually declared as being ineligible bids, right? And they were disqualified. Now, both these bidders actually challenged this move. And the grounds for the reason for disqualification are important to understand. ArcelorMittal was actually disqualified because it had investments in an entity called Uttam Gowla. And what that did was, or at least the records show, that this Uttam Gowla entity was actually a defaulting company on its own. And merely because we have an investment there, we being ArcelorMittal as a bidder, should you or should you not be disqualified? I think it's important to test this as we go on today, as we test 29A, the suggestions given by the law committee report, whether these really are a case and what should really be the position. New Metal, on the other hand, was disqualified because a minority shareholder in New Metal was a gentleman called Mr. Revant Ruya, who is actually, or is supposedly, related to the Ruyas and is part of the extended family. Again, should this be a case, should be a disqualification criteria or not, is something we'd like to dwell on as we go on today. This case also came up in something that the lawyers have more popularly understood as the Renaissance case, but this is actually Electro Steel, which is maybe not large as an NPA as SR Steel, maybe a fourth of that size, but that also came up in the first 12 cases. And in Electro Steel, what really happened was, when the bidding happened, Vedanta was the highest bidder, and the understanding was that let's go ahead with Vedanta's proposal. In fact, the committee of creditors even approved that proposal. That said, after this was done, the eligibility of Vedanta was actually challenged by Renaissance, saying should the Vedantas have been allowed to bid or not. And this decision today, in fact, they even challenged the Tata's bid, which I think was the second largest bid. And a hearing is still pending on this, but really the outcome is yet to be known. And again, since we are looking at these reforms, are we looking to keep some of these bidders out, and for reasons or not, is something we'll touch upon. The next big topic, and I think Vyapak, you rightly alluded to this in the beginning, is this whole issue about guarantors and guarantees being given and what happens to them in an insolvency proceeding. Well, of course, the starting point of all this is Section 14 of the Code, which actually really puts a moratorium on all other proceedings. While I'll leave it to Arjun to evaluate this further, I think the 2 or 3 obvious questions that come out is: should proceedings against a guarantor be stayed when the guarantor's assets are actually completely different from the assets of the corporate debtor? If we say they are to be stayed, should they be brought before a common forum, whether or not that guarantor itself is under a corporate under a CIRP process or not, or are we just dragging someone into that process, or is that really needed? And also a third question as to when really does a guarantee obligation become a debt for that guarantor? Is it when the guarantee is given? Should there be a crystallization of the debt at that point, an invocation? And these issues have come up. I think quickly alluding to the case again, this was SR Steel, I think, which raised the biggest questions, because there were news reports that some of the lenders to SR Steel said we are going to go ahead and enforce our guarantees. And the question arose, can they really do it given the moratorium that really existed? Interestingly, it seems that the guarantees were given by given to some of the lenders and not to all, and not necessarily covered everybody in the consortium. So that's another aspect that we will look at today. Believe there have been some other cases as well, not in the top 12 necessarily, where this guarantee question has come up. And given all our large companies are largely promoter backed, I think this question will come up in almost every single matter that we need to look at. I'll spend a couple of minutes talking about two other big trends that we've noticed come out of the first 12 cases, and we are probably going to take these up in our session next, but was important to point out. I think a very important topic that has come up is what is the timeline and timing of submitting a bid, and what is the finality when I submit a bid as a bidder. I think a couple of intermingled issues are here. The first big question is, can you revise a bid? And I think I'll take you straight to what happened in Binani Cement here. In Binani Cement, which is actually not a top 12 case, but still a extremely large case, an important case today, given not just this, but the nuances of the cement industry, Ultratech actually submitted a bid. That bid was outbid by Dalmia. Now, Dalmia Bharat was the entity that they were using. And subsequent to that, Ultratech actually came up with a revised bid, which they actually said we have contracted now, or are willing to contract with the promoters, and saying we'll buy over the stake, and our proposal is such that actually gives a much better deal to the lender, or at least an arguably a better deal to the lender, where the lenders were getting bought out almost at $1 for $1. Now the question is, and which is now proposed before Supreme Court to decide, that can really someone just improve their bid by having seen a bid that came up, or a competing bid that came up, and top it? Is that really possible? And also, let's not forget, there are a bunch of, in this case, the test might be sort of objective because it's the amount that is getting paid out, but there are subjective criteria in every bid. You are also thinking if the new bidder will actually run the business, which party is being treated how, etc. So all those questions, sort of heighten this issue. This also came up in Bhushan Power and Steel, which is BSPL, where I think one of the bidders, which is Liberty House, a UK-based enterprise, actually missed the deadline. Some of the newspapers called them late Latifs, but they actually went ahead and challenged the bid that Tata had given, which was the highest bid so far, saying, look, we want to challenge this. We arguably have a better bid, and we may have come late in time, but is it so late that you can't entertain our bid? And is there an objective or a subjective test to be applied there? The reason I mentioned that subjective or objective test, and we are coming late and what value you are delivering, takes me to that fourth topic that I think is overarching, which is this topic of liquidation value versus fair value. And while there have been amendments, and we'll take that up again, I think in one of the following sessions, not today, it throws out a very important question. This came up in a number of the top 12 cases that have been looked at. Alok Industries is one of them. Jyoti Structures is another one. Lanco Infra is another one. In all these cases, no viable resolution plan has been submitted or accepted till date. Why has that really happened? To our mind, I think the biggest reason is this mismatch between liquidation value and fair value, and where should the solution or the answer lie, other than case specific factors. But also throws out another question, that who all should really have a say when it goes to vote amongst the committee of creditors. Something that the report has looked at is the current construct of 75% voting fair. Should there be different numbers? Should we look at other laws to come up with this, or other jurisdictions? And another related question that it throws out is, does everyone have a say at the right time? Should a shareholder have a say or not have a say? Again, something that the committee report has dwelled on, and we'll take up. But giving you this background of these 4 or 5 overarching thoughts, without wasting time, I'm going to hand over to Simon, who will actually take up the first topic on eligibility and who's eligible and not. Simon, over to you.
Thanks, Karan. So we've talked a lot about the committee report that was issued in March of 2018. Just to give the participants a brief overview of the code of the report, the report seems to take into consideration the various teething problems that have arisen as a result of the code and its interpretation, and seeks to provide recommendations as to how to better or ameliorate these issues. I will just cover broadly what the recommendations are, or the key recommendations. And as Vyapak and Karan mentioned, we will be dealing with 2 critical amendments or propositions today. And we will be dealing with other recommendations and our views on those in subsequent sessions. So one of the first recommendations of in this committee report is to exempt micro, small, and medium enterprises from all the provisions or some of the provisions of this code, and the code or the committee requires for the central government to provide an exemption for such entities. The second key issue, which we will be discussing today, is to see who should be disqualified to submit a resolution plan, and how the purpose of who should be disbarred from submitting a resolution plan must be put into effect without unnecessarily creating a lot of inconvenience for genuine bidders. The third issue that has been decided by the committee is, how financial creditors and how operational creditors should be looked at, and especially homeowners and homeowners and home of whether they should be classified as financial creditors or not. The next one is in terms of classification or treatment of assets of guarantors, which is a very important point, which we will be discussing today. The next one is about voting thresholds, and the committee felt it appropriate to distribute various decisions and recalibrate voting thresholds basis different decisions that needed to be taken by the committee of creditors. The next one was to allow an exit provision to be provided with a higher threshold, so that issues raised by the Supreme Court are also put pen to paper. The next one would be to prevent the misuse of corporate insolvency process by corporate entities, and to ensure that adequate consents, including from shareholders, are actually taken before a corporate can voluntarily go ahead and file for an insolvency process. There are various other recommendations which deal with, or which take into consideration the various procedural problems being faced by the code, and we will discuss this perhaps at a later time. To come to the point that we are discussing, or the first sort of recommendation and the problems and the issues that have been faced really is who can submit a resolution plan. To take this group back to what a resolution plan really is, it is nothing but a plan that is submitted at the time of the insolvency process to to resolve the insolvency of the corporate debtor, and this plan must ensure that the company continues as a going concern. Now, there were various concerns as to who should be able to submit such a resolution plan and, in effect, take control of such a corporate debtor. And the concerns were really as to whether the original promoters or the persons that were responsible for the company going or becoming insolvent to acquire such a company and continue to be in control of this entity. Given this dilemma, there was an ordinance that came into effect which brought about the new 29A, which prescribed certain disqualifications, basis which, if you were disqualified, you weren't really allowed to submit a resolution plan. The intent being that the same controlling promoters or tainted promoters shouldn't be allowed to acquire and control a corporate debtor. Now, the exemption or the way the regulation was worded was vast, and it was very broad. So it caught, various people under who would really be disqualified. So this raised really a practical problem. Now, to give you what the existing 29A really is and what the new 29A proposed by the committee is, we need to go back to what the disqualification really is all about. So if you look at section 29A, let's divide the individuals that are today caught within this realm into A, B, and C. Persons A would be the person that is actually submitting the resolution plan. Person B would be any other person acting jointly or in concert with such person. So the principal submitter and any other person acting jointly or in concert with such person would be persons B. Person C would be persons that are connected to either persons A or persons B. So all of these today form the people against whom we need to check as to whether any of them are disqualified by the criteria mentioned in 29A. So 29A has the following criteria. One is if any of these people, A, B, or C, is an undischarged insolvent, is a willful defaulter according to RBI regulations, has an account or is the promoter of an entity that has been declared an NPA, has been convicted of any offense punishable with imprisonment for 2 years or more, is disqualified to act as a director, is prohibited by the SEBI from trading in securities or accessing securities market, has been the promoter or in control of an entity who has entered into a fraudulent transaction, pursuant to which an order has been made under the bankruptcy code, executed an enforceable guarantee in favor of a creditor in respect of a debtor against whom an application for insolvency has been made, has been subject to any such disability in a jurisdiction outside India, and has a connected person that has any of these disqualifications. Now, the word connected person was again defined very broadly. The term connected person today included any person who was or who was the promoter or in management control of such a resolution applicant. Secondly, also any person who was going to be in control of the corporate debtor during the implementation of the resolution plan. A holding company, subsidiary company, associate company of any of these two persons, or a related party of any of these two persons. So it caught within its within its ambit, a lot of people. What the committee thought was that, given how this 29A was really worded, it included people even though they didn't really have the intent to bid for this asset. So, in a situation, for instance, where a related party of an individual was declared insolvent or was subject to an offence punishable with imprisonment, even though they were not really acting jointly, they could be caught within the realm of a connected person, thereby making the individual or the applicant, the original applicant, ineligible, even though that individual really didn't have any say or any intent to pursue this resolution plan. So, as a result of this, there were a lot of practical problems faced by the industry. Now, all of the practical problems are not really resolved because the intent of the regulation the intent continues to be that any person that has contributed to this default or contributed to a like default elsewhere should not be allowed to participate in the resolution of an insolvent debtor. That spirit continues to prevail even with the recommendations of the committee. However, the unintended individuals have been sought to be removed from this definition. So, now what the committee has recommended is that the test of whether you are tainted or not be vis a vis persons A and connected persons of persons A. So, the individual B has been sought to be removed completely. The word connected person has been also expanded to include within its purview any person acting in concert with person A, similar to the definition included under the Takeover Code. As we all know, the definition under the Takeover Code is an intent based test which has to be tested vis a vis every acquisition or every resolution plan submitted. And it is not necessarily just a fact based test. Now, in terms of what the court has also committed, the committee has also proposed. One is if this individual has been an undischarged insolvent or a willful defaulter, that continues to be the case. What it has tried to expand is that with respect to classifications of this individual, the resolution applicant, or a corporate debtor in which it is in control of, whether it's an NPA today under the Reserve Bank of India laws or any other such law, would be captured within this ambit. The next one is that it has prescribed that instead of saying that this individual should have been convicted for an offense punishable with imprisonment for 2 years or more, they prescribe a list of offenses for which such an individual should have been imprisoned, as opposed to making it all encompassing. So, offenses that are perhaps not economic in nature or not criminal in nature, should not be captured within this disqualification. The next change that the committee has prescribed is that with respect to enforceable guarantees, it shouldn't just be an enforceable guarantee, but a guarantee that has actually been invoked by a creditor and remains unpaid. The next change that has been sought to be brought about is that where the 29A talks about a disability corresponding to these clauses in a jurisdiction outside India, it's not that it's in the past, but it should be that the individual continues to be subject to such a disability as opposed to something that has happened in the past. Now, let's talk about other two exclusions that the committee has sought to bring about. One is with respect to certain financial institutions. Now, what the committee has said is that financial institutions that have lent to a company and have perhaps converted their loan into equity should not be caught within the realm of this disqualification, because they could, for instance, be related parties. They could, for instance, be holding companies or subsidiary companies, and therefore they should not be included within this disqualification. So a blanket carve out has been has been brought about for such financial institutions. The next kind of individuals that the code has tried to exempt is any acquirer that has acquired such a corporate debtor, and as a result of a CRP or as a result of an insolvency process. Such an acquirer should also not be caught within the realm or should not be disbarred merely because it has within its fold a company that has a non performing asset. And therefore, what they've tried to do is ask for a extension, saying that if if only because of this reason you are disqualified, so long as a period of 3 years has not elapsed from that date, or and that account continues to be an NPA, you will still not be disbarred. But post 3 years from the date of acquisition, if that account continues to be an NPA, you will be disbarred. The next sort of change is to really look at what a connected person really is and how what change this really brings about. Now, the committee has proposed that limb 4 be added to the definition of connected persons. And limb 4 would be any person acting in concert with a resolution applicant. So that brings about an objective test. Any person that is actually acting in concert with the resolution a resolution applicant would be brought within the context of disqualification. However, if, for instance, you are just merely a company in which such a disqualified person holds an investment, um, just because of that, and you would not necessarily be disqualified in this context. What the committee has also proposed is that there are certain personal disqualifications, for instance, disqualification to act as a director, or you are prohibited from the SEBI. There are certain personal disqualifications. In such an event, the committee has proposed that these personal disqualifications not be linked to related parties. So therefore, if a related party is disqualified as a result of these personal attributes, merely because of that, the resolution applicant would not be disqualified as well. So, in a nutshell, this is what the committee has proposed in terms of the changes in 29A. Now, what does that really mean? One, it ensures that the spirit or the object of the actual amendment, meaning to say that people that have contributed or willingly want to participate in the resolution plan, should not be persons that are disqualified. If you are disqualified merely because a relative or related party, for instance, is subject to any of these disqualifications, that in itself should not disqualify you as a person to submit a resolution plan. Have problems that have been being faced by the likes of ArcelorMittal necessarily been dealt with or removed as a result of this amendment? The answer to that is probably no. Are there structures that can be looked at, basis which such an individual can participate, or a willful promoter can participate? It all goes back to the intent test, because if you are acting in concert with the resolution applicant, you would be disbarred, or the resolution applicant would be disbarred as a result of the taint that this person acting in concert with you carries. If, however, there is no such objective, perhaps you could look at how the law would permit unintended consequences to be to not disbar a genuine resolution applicant from making or submitting a resolution plan. So, in a nutshell, this is what the law really prescribes, and I think we can perhaps deal with our take on these amendments a little later, and whether in the question and answer session. I think maybe I will give it to you, Arjun, to talk about the guarantee bit.
Thank you, Simon. So I'll be dealing with a very specific topic over here, which is the treatment of guarantors or the position of guarantors under the Insolvency and Bankruptcy Code. Uh, I will also, and there's been a fair bit of judicial discourse on this point as of now. I'll be dealing with the cases in a little bit of detail so we have a proper understanding as to where exactly lies the point of the disconnect between what the different benches of the NCLT and the NCLAT, and in certain cases the High Court, have held with respect to how guarantors are to be treated under the Bankruptcy Code. The main issue of contention over here is how are guarantors to be treated with respect to the effect of moratorium on the principal borrower and in some cases the guarantor itself. So before we delve into directly the issues involved and the judicial precedents, let me just broadly deal with the concept of moratorium under the code. Under section 12 of the code, we deal with moratorium, which basically bars the continuation of pending proceedings and the institution of fresh proceedings against the corporate debtor, the corporate entity against whom the insolvency proceedings have been initiated. It also bars the corporate debtor from transferring, encumbering, or alienating its assets or any legal right or beneficial interest therein. Uh, the moratorium also bars the corporate debtor from participating in any action to foreclose or for any creditor to try and recover or enforce a security interest created by the corporate debtor, including under the Sarfazi Act. So this is the scope of moratorium and how the moratorium plays out with respect to the corporate debtor who is under the bankruptcy code, who is presently under CIRP proceedings. So whether during the pendency of the CIRP proceedings against the principal borrower, can a creditor move against the guarantor in such a situation? That's the main question which we are going to deal with. So the Allahabad High Court in Sanjeev Shriya has held that the moratorium will extend, or the effect of the moratorium will extend to the guarantor as well. In that case, there were certain proceedings which were already initiated at the DRT against the principal borrower as well as the guarantors. Thereafter, the principal borrower initiated insolvency proceedings by itself, which were admitted by the NCLT, thereby also initiating moratorium in respect of the principal borrower. So the question before the DRT was whether the proceedings should continue against the guarantors only, or whether the entire proceedings should stand suspended till the completion of the CIRP proceedings. The DRT said that the proceedings should be carried on in respect of the guarantors, and there should be a limited extent of suspension with respect to only the principal borrower who directly fell within the ambit of the moratorium. This question was then taken up before the Allahabad High Court, which ruled that the outstanding dues of the principal borrower were still in a fluid state, and that needed to be crystallized. And unless and until there was a crystallization of debt, the recovery proceedings before the DRT could not be continued even against the guarantors, and the entire proceedings should stand in a state of temporary suspension. Uh, Something which was slightly different as a perspective was the cases of Alpha and Omega and Schweitzer Systematic, in which the NCLAT had stated that the recovery proceedings which had been initiated by lenders in different forums. For example, in one of the cases, a court commissioner had been appointed to take over possession of the assets of the guarantor, the personal guarantor in that case. Whether these proceedings should stand suspended because the principal borrower was under the insolvency proceedings. Over there, the NCLAT emphasized on the word "its" as appearing in the section for moratorium, and said that the moratorium is applicable only in respect of the assets owned by the principal borrower himself itself. And that's why it said that only those assets which are appearing in the books of accounts of the corporate debtor or the principal borrower, only those assets will fall within the ambit of the moratorium, and the effect of the moratorium will not extend to the assets of the guarantor. And therefore they allowed the pending proceedings which were already initiated by the creditors against the guarantors. Now, the interesting part is that the NCLAT itself has provided a slightly contradictory view in the Wiesn's case, which is a recent judgment of the NCLAT, in which there were SARFAESI proceedings pending against the personal guarantor of the principal borrower. These SARFAESI proceedings were at a very advanced stage when the principal borrower decided to file an application before the NCLT to initiate insolvency proceedings, which were admitted. And post that, the principal borrower approached the NCLT for a suspension of the SARFAESI proceedings against the guarantor as well. The NCLT as well as the NCLAT stated that there should be a suspension of the SARFAESI proceedings against the guarantor as well, because the moratorium and the effect of the moratorium on the corporate guarantor or the principal, on the corporate debtor or the principal borrower would extend to the guarantor. But there is a very interesting observation by the NCLAT in respect of any proceedings which possibly could be initiated against such a guarantor. The NCLAT states that bankruptcy proceedings against the personal guarantor can be initiated before the NCLT even during the pendency of the insolvency proceedings against the principal borrower, which means that because there is a moratorium in place, therefore you cannot initiate proceedings at any other forum than the same adjudicatory forum which is trying the insolvency proceedings with respect to the principal borrower itself. It has given liberty to State Bank of India to initiate bankruptcy proceedings in respect of the personal guarantor before the same NCLT. Although Part 3 of the code, which deals with bankruptcy proceedings of individuals, are yet to be notified. This effectively, so now if we extend the logic with respect to initiating bankruptcy proceedings in respect of a personal guarantor to that of initiating insolvency proceedings in respect of a corporate guarantor, then that entails that the moratorium should not effectively bar any creditor to initiate insolvency proceedings with respect to a corporate guarantor before the same adjudicatory authority or before the same NCLT. Now, this position has also been reiterated by the law committee, by the insolvency law committee in its report, wherein it has said that suitable amendments should be made to section 60, whereby simultaneous proceedings can be carried out against the corporate debtor as a corporate guarantor as well before the same adjudicatory authority, which is the same NCLT bench where proceedings against the principal borrower are currently underway. If we now deal with just the point of law and the general concept of law, before the introduction of the code, there were many cases with respect to how do you proceed against a guarantor when there exists a cause of action to invoke your guarantee. This question has reached the Supreme Court in many occasions. There's the Saraswati Tandon case, there's the Allahabad Bank versus Canara Bank case, in which they have specifically stated that the liability of a guarantor coexists with that of the corporate debtor or the principal borrower, therefore giving the creditor and the lender a distinct right to initiate proceedings against the guarantor even before it decides to initiate proceedings against the principal borrower itself. Therefore, keeping in line with that position of law as propounded by the Supreme Court and some of these judgments, it is definitely, there should be clarity once and for all with respect to this position as to how do you treat a guarantor when insolvency proceedings are already underway with respect to a with respect to the principal borrower. But if we now move to a different factual situation, which is if there are insolvency proceedings which are underway with respect to the guarantor itself, are you able to invoke a guarantee post the insolvency commencement date? The insolvency commencement date being the date on which the insolvency petition is actually admitted by the particular NCLT. After admission of the insolvency application, if there exists a position where you have if there is a default by the principal borrower and you are in a position to invoke the guarantee, are you allowed to invoke that guarantee? We have some judicial precedents on this point as well. The NCLT Delhi and Axis Bank versus EduSmart has dealt with the situation and ruled that the moratorium under section 14 will effectively bar you from invoking your guarantee post the insolvency commencement date, because because the section of moratorium states specifically that enforcement of security interest created by the corporate debtor in respect of its property is barred. Further, it has also stated that any only those liabilities can be included in the total bucket of liabilities with respect to the principal borrower, with respect to the corporate debtor, which are alive at the date of the insolvency commencement. Which means that if you have not invoked your guarantee as on the insolvency commencement date, it only exists as a contingent liability. It is not a debt in the books of accounts, in the books of the corporate debtor, and therefore you cannot invoke such a guarantee post the insolvency commencement date. However, over here, if we are to just compare the section of dealing with moratorium under the code as well as a similar provision under SICA, we'll see that in SICA, if I could just read it out, uh, no proceedings for the winding up of the industrial company or for the execution, distress, or the like against the properties of the industrial company or for the appointment of a receiver in respect thereof. And this is the most important point. And no suit for the recovery of money or for the enforcement of any security against the industrial company or any guarantee in respect of any loans or advance granted to the industrial company. So over here there is a specific wording with respect to guarantees and loans. In respect of guarantees, we find no such specific wording in the moratorium section under the code. The section under the code specifically talks about any action to foreclose, recover, or enforce a security interest in respect of any property which has been created by the corporate debtor. Maybe there can be some sort of a clarification by way of an amendment which makes this point abundantly clear as to whether one can invoke a guarantee after the insolvency proceedings have been initiated against a corporate debtor.
Thanks, Arjun, and thanks, Simon, for elaborating two specific provisions which are part of the proposed amendments. As Simon mentioned, there are many such amendments which have been proposed, and the deliberations are still on. We would deal with some of those as we go along in this series because we want to continue doing this over a period of time. I think. While we are debating as to what kind of amendments should be brought in with vis-a-vis the ineligibility, I think the question also remains to see whether we even need such a provision in the first place. I think some of these discussions we would want to carry on as this series proceed, because do we really want to complicate the code by bringing in provisions which are subject to different interpretations and challenges, or do we want to keep it very simple and allow the committee of creditors, which are the nodal nodal point as far as the whole process is concerned, because everything is done at their behest and everything is done under their consent, to allow as much participation as possible, because ultimately they can take an objective or a subjective criteria depending upon the bidder rather than bringing in such eligibility. The other point we also want to raise and at some point debate in detail as to whether the provision which again is part of the challenge before the Supreme Court as to taking away the powers of the directors and taking away the powers of the promoters in terms of management. Is that the right way, or are we creating too much of oversight as to how this insolvency proceedings or the committee of creditors would run the company pending the resolution, since some of the companies and promoters may not be treated similar to the recent examples where of course the economy is suffering because of the fraudulent actions taken by the committers. Should we put them or paint them in the same brush? So I think there are many more larger questions to the law, many more interesting issues which possibly would need to be addressed as we go along, uh, addressing the current needs under the insolvency. But at the moment, I think we need to really focus on the some of the very specific amendments raised by the committee and also suggest what more can be done. So with that, I think we will open the floor for questions, because idea of this series is not to just give some kind of a lecture on where it stands, but I think the idea of this series is to bring along some of the important suggestions which can go to the relevant people looking at the amendments at this point. So if anybody has questions or comments, feel free to raise at this stage, and we will be happy to address them and include as part of the white paper which we would be releasing post this series. With that, I hand over back to the holder of the call to open the question answer sessions. Before that, if Simon or Karan or Arjun, you have anything, maybe you can add
So
the
just to
point.
add that to your point, if anyone wants to even email us questions or suggestions on the code or the committee report, do feel free to email us at nda@nishithdesai.com. We will be happy to answer questions and engage in a lively debate aside from these telecoms as well. We can open the floor for questions.
Thank you very much. Ladies and gentlemen, we will now begin the question and answer session. Anyone who wishes to ask a question may press star and one on your touchtone phone. If you wish to remove yourself from the question queue, you may press star and two. Participants are requested to use handsets while asking a question. Ladies and gentlemen, we will wait for a moment while the question queue assembles. We will take the first question from the line of Suraj Singh from Wells Fargo. Please go ahead.
All right, thank you. You also talked about this court case and the clarity that has come from Supreme Court as to whether the notice and the claim can be filed by the counsel of the creditor. May I know what is the response, or what is the clarity that we got from the court on this?
Yeah, so the Supreme Court in the case of Macquarie Bank has stated that the demand notice which is to be issued on behalf of a company for example an operational creditor can be issued by its advocates. Earlier on certain cases, the NCLT and the NCLT had stated that an advocate would not qualify as an authorized representative of the operational creditor, and has barred and has dismissed those applications filed by such advocates. But this position has been reversed by the Supreme Court. The Supreme Court has basically tried to hold the operation the has tried to keep the scope and spirit of the code intact by removing operational hurdles, and that's why it has allowed advocates to issue such a demand notice and file an application on behalf of creditors as well.
All right, thank you.
Thank you. A reminder to the participants, anyone who wishes to ask a question may press star and one at this time. We have the next question from the line of Nupur Nadir from GMR. Please go ahead.
Hi, I wanted to understand if a guarantee holder, the person to whom a guarantee has been issued, can he be a financial creditor? Would a guarantee in any circumstance fall under the definition of financial debt?
Yeah, so if we see the definition of a financial debt, then a guarantee holder can also be classified as a financial creditor, and they can also initiate proceedings against the company which has issued the guarantee in case there is a default by the principal borrower, and the guarantee agreement has been invoked and no payment has been made, which means that if there is a default under the guarantee agreement, then appropriate proceedings can be initiated by the creditor who is the guarantee holder as a financial creditor
under the code.
under the code.
So if I'm reading the definition of financial debt, so where I can see guarantee fitting in would be either in H, whether any counter indemnity obligation in respect of a guarantee is given, which is not really the guarantee holder, or in point number I, which says amount of liability in respect of guarantee for any of the aforesaid items.
Yeah,
That's correct.
that's right.
So you think I is the one which captures a guarantee holder as well?
That's correct.
That's right.
And therefore, in some of the cases in the past which Arjun dealt, also allowed the initiation of proceedings invoking the guarantee. I think the issue was whether it can run in parallel, whether it has to be stopped because of moratorium, but there was no question, or there was no confusion in relation to whether they fall under the provisions of the code, subject to the other criteria being met. So we do not see a problem vis-a-vis invocation of that guarantee and then subsequent application being made under insolvency code for the purpose of going through the resolution uh, process.
Okay, just one follow-up question on this from my colleague.
Yeah, so once let's say a guarantor pays off and discharges the principal obliger's debt, then the guarantor has a right to recover that money from the creditor, principal debtor.
Correct.
In such a case, would that be a financial debt?
Yeah. So absolutely, under Contract Act, a guarantee is a tripartite contract. As you rightly mentioned, guarantor will step into the shoes of the lender, and in that case, there shouldn't be an issue. It's just exchanging who was that party, and whether that party formed part of COC or not will remain the same. The one thing you'll be wary of is guarantors are often related parties, and then they'd be debarred from voting. But other than that, there shouldn't be any change because it's mere replacement of who the lender then becomes, and is entitled to the same benefits typically, unless you've contracted out of those.
Okay,
Thank you.
Sure.
Thank you so much.
Thank you. A reminder to the participants, anyone who wishes to ask a question, please press star and 1 at this time. We have the next question from the line of Rachita Shah from Axis Capital. Please go ahead.
This was regarding the eligibility criteria. In case of IBC, it states that if a person who is giving a resolution plan is connected to the existing promoter, then that person will be debarred, right, from giving the resolution plan.
That's correct. But
Not connected to the promoter, connected to the resolution applicant.
Correct, the resolution. Okay, so the existing company, I mean the corporate debtor.
Okay, let Simon answer, but the connected person definition relates to people who are connected to the resolution applicant, not the corporate debtor or the promoter directly. But as part of resolution applicant, of course, there are certain people who would be debarred, which may or may not include the promoters, because it says any entity which is a promoter of a defaulting entity.
Yeah,
But maybe Simon can explain it better.
Just to sort of go back to your question, maybe let us hear the full breadth of it. But if we look at the definition of connected person, limb 2, right? It says any person who shall be the promoter or in management or control of the business of the corporate debtor during the implementation of the resolution plan. It doesn't go back to prior to, it says during the implementation of the resolution plan, and therefore it is forward looking.
So, for example, if I have my existing promoter of the company which has defaulted, the existing promoter is, along with a financial or a strategic investor, giving a resolution plan.
Yeah.
And the existing promoter will be a part of the resolution plan. I mean, it might have a minority stake or something of that sort.
That's correct.
Then
But in that situation, you will not be covered by the word or the definition of connected person, but you will be covered because that person would be technically acting jointly with you, and therefore the criteria of disqualification is tested vis-a-vis that person as well, and both the individuals will be disbarred accordingly.
So they will be disbarred, isn't it?
That's correct.
Under
Because-
clause C
Yeah.
of 29 and not under the definition of connected person.
Correct. Under clause C
So,
or could be
to
clause
your
B
question,
also.
there is a
B or C.
distinction when the promoter himself is either on his own or jointly submitting a resolution plan or is not submitting one. And I think that's, in your question, it's the same. So, we apply the test as Simran mentioned.
All right.
And that's the entire debate on Asana Mithun, including various other sort of
Yeah.
such issues. Yeah.
Sure.
Thank you. A reminder to the participants, anyone who wishes to ask a question, please press star and 1 at this time.
If there are no more questions, I think we can close the conference.
If there are no further questions in queue, you may want to give some closing comments.
Sure. I think we thank you all for attending this webinar. We expect to have the next webinar 2 weeks from now, which is the 24th of April. We will send you details. As we have stated before, we look forward to any comments or suggestions that you do have on the committee report or any other provision of the code that has not been addressed. We propose to submit a white paper on our recommendations and concerns of basis what the committee has suggested, and that is that they may not have considered as well. And we look forward to participation from you in submitting it. Thank you all. Good evening.
Thank you very much. Ladies and gentlemen, on behalf of Nishith Desai Associates, that concludes this conference call for today. Thank you for joining us, and you may now disconnect your lines.